right, guys, we're going to get this started. This is Judge Pinky S. Carr from the Cleveland Municipal Court. This is the first of the three judges that I talked about just the other day, and we're going to get into and breaking down a little bit of what she was reprimanded for and some of the details behind it. And yeah, guys, let's just get to it. All right, guys, so here it is: the Ohio Supreme Court's slip opinion for the disciplinary counsel versus now former judge Pinky S. Carr. This just talks about what the basic charges are, and I'll just let you guys pause it. I'll let you guys pause it, so I'll give you a break on each page. All right, so this talks about her history and what they're telling, what they're saying about her, her counts, information provided, this is the stuff, this is what I've said at the beginning of all this. This is pretty much all that broken down. But let's get into count one. There were 5 counts with multiple instances of each count. And this one, issuing capious warrants and making false statements, she'd issued about, if I remember correctly, it was 34 capious warrants or bench warrants for failure to appear. This is like, okay, here we go. So in March of 2020, the whole curb the spread for the vid was going around, and everyone was doing it, trying to make things better for everybody, help slow the spread of the vid. And likewise, the Cleveland Municipal Court presiding judge Michelle Early had issued an order, a directive, that all court cases from March 16th through April 3rd of 2020 were to be scheduled 3 weeks out. Well, Judge Carr, in all of her infinite wisdom and power, decided, screw that. I'm going to do what I want. And this is when power goes unchecked. This is what happens. On March 16th is when it was supposed to go into effect. Judge Carr, screw you, I'm doing what I want. And that day, let me clarify. The rescheduling of court cases was for people that were from the outside that would be coming in. So any criminal and civil matter that was not for a person that was incarcerated. If they were already incarcerated, they would still have their court hearings. So anyone coming to the court would be rescheduled. So on March 16th, this happened to, I believe it was 8 criminal cases which defendants had not been jailed that didn't show up because they followed the court's order. Now, the court clerk was ordered to reschedule everything, and the court clerk did. So she issued, she issued warrants for the arrest of people with bonds from $2,500 to $10,000, which is absurd. And you'll see why it's reprehensible, the way it went down and what she used them for. So on the record, in court, and in her journal entries, it was warrant to issue. Now, defendants that were able to show up to court and still had their court, she would just unilaterally just get rid of the citations and fines and everything. She basically just, here you go, you're brave enough to come here, so no fine, no fee, we're done. So it's like it didn't even happen. On Tuesday, March 17th, the same thing happened, except there were 7 people. So in the first 2 days, it was 15 people who didn't show up because they got a new subpoena for court to show up 3 weeks from the time of their original court hearing. The public defender asked about it, and she told him, make sure your people are here. He's like, we shouldn't reschedule. Nope, make sure they're here. Okay. So then after clearing the March 17th docket, she learned that pursuant to the administrative order, the person responsible for scheduling court cases had canceled her civil docket for March 26th. In an open court, she told him, her bailiff, to tell him to get his ass back on the phone and put all her civil cases back on. But he'd already sent out postponements, and because of it, he had to call everybody back and notify everyone to appear as originally scheduled. So day 2 of all this, March 17th, the Plain Dealer posted an article in Cleveland.com talking about this judge issuing warrants for people to a closed court. She denies it. All right, so she denies it. On March 18th, in court, she criticizes the Cleveland.com for inaccurately reporting things that she was not doing it, and she was interviewed by a reporter, and the reporter said, "And you are not, to be clear, you are not issuing any warrants." And Carr replied, "Absolutely not," but that was untrue. And then in a text message chain to Judge Early, the presiding judge of the Cleveland Municipal Court, the conversation went like this. The judge asked if she was issuing warrants, and she responded, "Too late to ask that ridiculous question. My journal entries reflect Corona Day 1, 2, or 3, time case was called, and no defendant or failed to appear, in which my journal entry notes say no warrant to issue." Well, that's absolutely false, because in her journal entries it says issue warrants $2,500 to $10,000 despite that order. So the board of professional conduct found that the administrative statement was proper, and because of her actions and failure to follow that order, it was a costly burden to the administration of justice. And when Early had learned that Carr had in fact issued warrants, she had to review all of Carr's entries, recall all the warrants, reset all the bonds, issue proper summonses, and reschedule her civil cases. Now, the Office of Public Defender actually went to the 8th District Court of Appeals seeking action from the higher court, in which they agreed and made her stop what she was doing and basically saying that you are not allowed to do this. You must follow the order, and found that she violated multiple policies and rules regarding how a judge and a lawyer is to behave in accordance with like state law. And they found that Carr had very publicly flouted her disregard of a court order that was designed to ensure the safety of the public and the court's personnel during the pandemic. So they agreed that she had violated Judicial Conduct Rule 1.2, 2.2, 2.5b, 2.8b, and Professional Conduct Rule 8.4c, which is lawyer, 8.4d, which is lawyer. So we have 6 different court rules and procedure rules that she was not to violate, but she chose to violate them. So what she did is 34 people had warrants issued to a closed court when they didn't appear. 34 people, bonds from $2,500 to $10,000. Can you imagine being someone hit with a $10,000 bond? You're stuck in court. Sometimes she would even say no 10%. So you got a $10,000 bond, hope your family likes you enough to deal with a $10,000 bond, because this judge is something else, man. I almost want to get into B, count 2. Yeah, let's do it. Count 2, ex parte communications. And if you don't know what that means that's a communication without an attorney present. All right. Improper plea bargaining and arbitrary dispositions. This is hilarious. Like, it just gets worse, guys. As we go on, it just gets worse. What this judge did just gets worse. See, we're here. Here we go. 34 cases with ex parte communications and improper plea bargaining. In open court on June 15, 2020, she told her staff, "The prosecutor isn't here. Let's see how much we can get away with." She would echo that multiple times. She would say things like on the 18th, "Well, the prosecutor isn't here, so we need to get as many of these done before he or she gets here." And then offered the defendant a plea deal which he had accepted. Now, she admitted that she would routinely conduct hearings like this without a prosecutor being present, so that she could avoid complying with the requisite procedural safeguards set forth by Ohio Revised Code 2937.02, which required a judge to inform the accused, among other things, of the charge, the identity of the complaint, the right to counsel, and the effect of their plea, their pleading. Guilty, not guilty, no contest. Not guilty, you could get a trial. Guilty, you may be civilly responsible as well. No contest, based on the affidavits and the filings, the judge will make a decision or a ruling, and there were no civil liability. That's basically what that is. And then she violated Criminal Rule 11, Traffic Rule 10, both requiring a judge to engage in a personal colloquy with the accused to ensure that a plea is knowingly and voluntarily entered. So that means that they know what the plea they're entering is, and do so voluntarily. Now, here's where it gets interesting. She would practice law from the bench and unilaterally recommend pleas to unrepresented defendants. So, in other words, she would recommend they take this plea from the bench to someone that doesn't have an attorney. That's practicing law from the bench. That is illegal. You cannot do that. She would do this when unrepresented defendants and no prosecutor was there, and people accepted the pleas without explanation or discussion of the consequences of entering that plea as required by criminal and traffic rules. At least 6 of the 34 cases in this count, she unilaterally amended the charges against the defendant and falsely attributed those amendments to the prosecutor in her judgment entries. What that means is she would change the charge without the prosecutor's knowledge or approval. She cannot do that. But she said the prosecutor agreed to it. So they got her on 6 charges right there. That right there should be 6 criminal charges. She falsified court documents and she perjured herself. Those should be 6 charges right there alone. All right. After entering these no contest pleas on behalf of defendants, which you can't do. By the way, Judge Amy Burling, you did that yourself in Toledo Municipal Court. I was there. I witnessed it. You're garbage. So after entering these no contest pleas on behalf of defendants, she routinely found them not guilty. And I'm trying to wrap my head around this. She's like, you should just plead no contest. Take care of you. All right, no contest. Not guilty. Even when she found them guilty, she would just waive the fines and costs without any inquiry into the defendant's ability to pay. So when you file or when you go to pay something, you ask, I don't have the money. And there's what's called finding of indigency. So they would have a hearing, or you fill out some paperwork and they discuss the paperwork to find out how much you could pay, based on what your bills are and what your income is. And if you're indigent, sometimes courts would just waive the fees. But they didn't do that at all. At all. She would falsify her journal entries to conceal her actions. She frequently stated that she was waiving fines and costs based on their birth dates or its proximity to the date of the hearing, a holiday, her own birthday, the birth dates of her family and friends, and even when the prosecutor was present in the courtroom. Her entries in at least 24 of the 34 cases identified in count 2 falsely stated that she had conducted ability to pay hearings, which is that indigency hearing, and had determined that defendants were unable to pay fines or costs. So 24 more counts of perjury and falsifying court documents. So we're at 30 charges right there. For example, one individual named MT was charged with speeding, which is a 4th-degree misdemeanor, and a seatbelt violation, which is a minor misdemeanor. He was arraigned before Judge Carr on June 15, 2020. Earlier in the day, she had waived the defendant's fine and costs simply because the defendant's birthday was in June, with no prosecutor present. She told MT, I'll give you the same deal even though your birthday's in September. She then asked MT whether he'd like to plead guilty to a non-moving violation. He nodded his head and Carr replied, Yeah, I see your birthday is in September. We'll waive your fine and costs. Okay, goodbye. You're free to leave. MT, you need to verbally state things. So he didn't enter an oral plea, which you are required to do. Nor did Carr advise him of the consequences of entering his plea. Yet she dismissed the speeding charge, entered a guilty plea for the seatbelt, and wrote fine and cost waived. Now, you guys might have seen the judge in Rhode Island, Judge Caprio. He does this. But he holds like impromptu or, kind of off the cuff indigency things, and he hears the story and he makes determinations from there. She's not even doing that. Judge Caprio is amazing. We need more people like him in the bench that take humanity and life problems into factor, not just here's what it is. But this lady isn't even doing that. She's not taking in any consideration. She's just basically flinging stuff at the wall to see what sticks or not. She also checked boxes, falsely indicating she had conducted these hearings. So there's another case. This one's a good one. MH was charged with 4th-degree misdemeanor, open container, and loud noises. The prosecutor was not present when he appeared before Carr for his arraignment, and she asked how he wanted to proceed. He said he wanted to plead no contest to both offenses. She suggested that she amend the loud noise charge to a minor misdemeanor, let him plead to that, so he would not have an alcohol-related offense on his record. I'm almost okay with that. That's kind of cool, you know? She also told him the course of action would allow him to avoid a mandatory fine of $75 and require him to pay just $5 plus court costs. And on the entry, she put prosecutor amends the charge, which that right there is against the law. That is another charge of falsifying court documents and perjury. Her practice of issuing journal entries falsely attributing amended charges to the prosecutor or falsely stating that she had conducted the ability to pay hearings may violate Ohio laws, Ohio Revised Code 2921.13, which provides that a person who knowingly makes a false statement in any official proceeding on a form, record, or other writing is required by law, or in a document that reports or purports to be a judgment and is filed with the clerk of court of records, commits an offense of falsification, a first-degree misdemeanor. First-degree misdemeanors in the state of Ohio hold up to 1 year in jail. So this right here is 30 years potentially. 30. But yet, no criminal charges have been filed on her to this day so far. And they just got done with the Ohio Supreme Court's ruling. So I'm not going to hold my breath that she's going to be charged. I absolutely do not believe she will get a single charge, not even a minor misdemeanor, $150 fine. I honestly don't believe it. So based on the party stipulations and the evidence, the board found that Carr's conduct violated Judicial Conduct Rule 1.2, 2.2, 2.8b, and 2.9a, prohibiting a judge from initiating, receiving, permitting, or considering ex parte communications except in specifically enumerated circumstances. There's only certain situations where you can have an ex parte hearing, one of which being like a civil stalking protection order. The victim or, what is the word? Respondents? Petitioner. The victim or petitioner will sit down in court with a magistrate or a judge and discuss the issues at hand. The judge will determine if there's something there and then issue the ex parte civil protection order or, stalking protection order, whatever it may be. That's one where the respondent or defendant doesn't have to be there. There's no attorneys that have to be there. So there's certain situations where, yes, this can happen, but it's all on the record and it's all documented. She also violated Professional Conduct Rule 8.4c, 8.4d, and they adopt these findings of misconduct. So we have 34 cases in which I was wrong about the 34 for the warrants. As actually, I think it's 31. It's on another document. But here, she violates 34 instances where there were ex parte communications or improper plea bargaining. That is unacceptable. You or I would absolutely have the book thrown at us. But because she is a judge and a lawyer and she's got friends in the prosecutor's office because she was an assistant prosecutor for 13 years, they're not going to do a damn thing to her. You or I would be under the prison at this point. We would be charged, tried, convicted, and buried. But yet here she is, suspended for 2 years, and she can get her law license back. All she's going to do is go to a local college and teach for 2 years and then reapply. I mean, and no harm, no foul. Oh my goodness, guys. There's so much more to this. We're going to do a part 2, part 3, maybe a part 4. I'm going to try to keep this to a 3-parter if I can. So guys and gals and furries and whatever whatever floats your boat. I'm Great Lakes. As always, take care of yourself. And unlike Judge Carr, take care of each other. I'll see you in the next one.